Straight ahead, Crime Daily. A grand jury makes a decision in the police killing of Breonna Taylor. A breakdown of an explosive announcement.
Also,
I plead guilty, Your Honor.
that was his plea. So why is this defendant trying to change his story after prosecutors say he recorded a murder?
It is horribly graphic. It's absolutely monstrous.
And how police say they solved a 46-year-old murder. On Law&Crime Daily, covering court cases from coast to coast.
And welcome, everybody, to Law and Crime Daily. I'm Aaron Keller, along with Brian Buckmeyer and Terry Austin. A Kentucky grand jury recommending no charges directly against the police related to the shooting death of Breonna Taylor. That announcement concluding a grand jury probe into the shooting, which happened as plainclothes officers busted down Taylor's door in an attempt to execute a no-knock warrant. Taylor's boyfriend thought the officers were intruders. Gunfire erupted, with the police firing most of the rounds. Two of the officers involved, Miles Cosgrove and John Mattingly, are off the hook, but the grand jury decided Officer Brett Hankinson should be charged with 3 counts of first-degree wanton endangerment. That's for firing shots into neighbors' apartments. Hankinson has already been fired from the force.
The grand jury voted to return an indictment against Detective Hankinson for 3 counts of wanton endangerment for wantonly placing the 3 individuals in apartment 3 in danger of serious physical injury or death. The charge of wanton endangerment in the first degree is a Class D felony, and if found guilty, the accused can serve up to 5 years for each count. Our investigation showed, and the grand jury agreed, that Mattingly and Cosgrove were justified in the return of deadly fire after having been fired upon by Kenneth Walker. Let me state that again. According to Kentucky law, the use of force by Mattingly and Cosgrove was justified to protect themselves. This justification bars us from pursuing criminal charges in Miss Breonna Taylor's death.
The Attorney General's office says Taylor was shot 6 times, not 5, as her death certificate listed. And the FBI crime lab concluded the fatal shot was fired by Detective Cosgrove.
There was no video or body camera footage of the officer's attempted execution of a search warrant at Miss Taylor's residence. Video footage begins at the point that area patrol officers arrive at the location. Therefore, the sequence of events from March 13th had to be pieced together through ballistics evidence, 911 calls, police radio traffic, and interviews. We utilized information from the Kentucky State Police, local medical examiners, as well as working with the FBI crime lab in Quantico to secure a trajectory analysis and ballistics report. Our team conducted interviews in this case and spent thousands of hours examining all of the available evidence. We concluded our last interview in this case this past Friday and began our grand jury presentation on Monday.
Okay, Brian, let's talk about the charge that was filed here. What does the one officer face, and why do you think the other 2 ultimately were not charged?
So I don't think the other 2 were charged based on the fact of how this all went down. I think the very fact that Kenneth Walker is accused of shooting first in self-defense, as was eventually found out, because he was treated like everyone else. He was arrested, he was confined, and then they found the truth. The officers, they get the benefit of the doubt that Kenneth Walker and many people don't get, but they ultimately came to the same decision, that those 3 were acting responsibly in terms of the law and self-defense. However, the third officer, he acted in a way that was wanton and disregarded human life, and that's why he's getting that D-class felony.
Okay, so Terry, the Attorney General said this grand jury started digging into things on a Monday morning, and there was a decision by noon on Wednesday. Is that too short of a time, in your opinion, to dig into a case of this magnitude?
Absolutely, particularly since they had so much time. This crime occurred on March 13th, and the average length of a grand jury, especially as it's on the state level, it varies from a week or 2 weeks or, a month or more. And here to say that it occurred in a couple of days, I don't think that the Attorney General's office made sure that all of the evidence got before the grand jury. It seems as though only evidence about this one particular charge for first-degree wanton endangerment was presented.
And Brian, we're hearing of discrepancies here. Why no body camera footage? Why are we hearing neighbors telling reporters that they heard nothing from the police, but then the authorities are saying, no, there's evidence that some neighbors did hear the police announce their presence?
Yeah, so the evidence is coming out as the prosecutor wanted to, because the prosecutor has the sole discretion as to how they prosecute cases, both at trial and in the grand jury. So they're presenting information in one way, and that's how it came out. No murder, no manslaughter, only the charge that they can prove the most beyond a reasonable doubt, and not the way that it operates for so many other defendants in this country.
Good points, Brian and Terry. The widow of NBA player Kobe Bryant has filed a civil lawsuit against the Los Angeles County Sheriff's Department, claiming deputies there took unauthorized photos of the helicopter crash, which claimed the life of the basketball star. The private charter craft went down in heavy fog about 30 miles northwest of Los Angeles back in January. Bryant, his daughter, the pilot, and all 6 others aboard that aircraft died. Terry Austin explains the lawsuit.
The complaint alleges civil rights violations, the intentional infliction of emotional distress, and invasion of privacy. These images from the scene of the crash were recorded by the National Transportation Safety Board and were authorized for release. The lawsuit says the county sheriff promised widow Vanessa Bryant that the site was secure. However, 8 deputies at the scene used their cell phones to take pictures of the dead victims for their personal gratification. The images were shared within the department and even at a bar, the lawsuit claims. A bartender was so appalled that he filed a complaint. The lawsuit says the sheriff told the deputies that if they deleted the so-called illicit photos, they would not be disciplined. The lawsuit characterizes the official response as a cover-up. Mrs. Bryant feels ill at the thought of strangers gawking at images of her deceased husband and child, and she lives in fear that she or her children will one day confront horrific images of their loved ones online.
Thanks a lot, Terry. And now to Brian Buckmeyer for some perspective on this.
Yeah, Aaron, I spoke earlier today with retired SWAT team member Lisa Lockwood. She says the crime scene techs are the ones who are supposed to be taking photos in the field, not officers, unless there's an emergency which requires an officer to record the scene before the tech arrives. Now, she criticized the officers for taking pictures in the case, but said discipline would be unlikely unless a pattern of bad conduct emerges over time.
Actually take out your camera and take personal photos of a crime scene in a place where it didn't warrant that is conduct unbecoming. And I believe Vanessa has every right to do what she's doing, because once it was leaked and it was found out and reported, she contacted LAPD and basically said, why is this happening? What kind of discipline is being done? And the response that she got was, they were told to delete the photos. I mean, it was so dismissive and so disrespectful to this woman who lost her husband and her child. The amount of mental anguish knowing that these exist and they're out there in the public is so grotesque and disheartening. The police officers could have sold those images, and this could have gotten a lot worse. So is it cause for firing? Probably not. And it would be based on priors with the police officers.
Now, Lockwood says that while officers do have the legal right to show pictures that the public has already seen of a crime scene, they should not be photographing what the public is blocked from actually seeing.
So, Brian, what's disturbing here, in my opinion, is that Vanessa Bryant asked for a perimeter, an exclusionary zone around this scene. Officers said they would grant it. They just didn't police it against themselves.
Exactly. It's another situation where we are asking for our men and women and people in blue to protect us, not just from violence, but also our privacy. And when we're thinking that others are going to harm that, it's actually the officers who are harming the individual instead. And that's sad and tragic in so many ways.
Terry, the sheriff basically said this is a problem in every law enforcement department. My question, though, is this a strong or a weak case for the widow of Kobe Bryant?
I think Vanessa has a very good case because she's claiming invasion of privacy, and I think clearly this was an invasion of privacy. She's also claiming intentional infliction of emotional distress, and the distress that she must have suffered knowing that these pictures were out in the public domain is very stressful. So I think she has a good cause of action here, and hopefully she will prevail.
A sad story all the way around. And still ahead on Law and Crime Daily, a new lawsuit against Carole Baskin, the star of the docuseries Tiger King. But first, a defendant tells a judge he was guilty after spreading photos of the murder he said he committed on the internet. So, how can he suddenly change his mind? A young upstate New York man is trying to walk back his guilty plea after he originally admitted that he killed his 17-year-old girlfriend and then posted pictures of the victim's body on the internet. Victim Bianca Devins died in July 2019 after attending a concert in New York City with Brandon Clark. Prosecutors even say Clark made a video of himself killing Bianca Devins. Clark admitted to the killing in open court, but now he claims his original attorney coerced him into admitting to the charges. These were some of the defendant's own words at a plea hearing this past February.
On the date of July 14th of 2019, while you were here in the city of Utica and the county of Oneida with intent to cause the death of Bianca Devins, you did cause the death of Bianca Devins. Is that a true statement, Mr. Clark?
Yes, Your Honor. I know that sorry's not enough. I know that I won't take back what I did. Every day since July 14th, I've thought about it. I've thought about the terrible things I did that day, things that the word tragedy really isn't enough for. I thought about the lives I've torn apart with my actions. And I've thought about Bianca and how she didn't deserve what happened to her.
At the time of that plea hearing, the defendant's guilty admission came as a relief to the victim's grandfather.
It would be a very hard thing to go through that trial, and we're grateful that he has chosen to plead guilty. One statement to me that stood out was that he said Bianca did not deserve this, and that's right. She did nothing to deserve this. So in that way, he's taking full responsibility that these were his actions, done by him, caused by him.
We're missing Bianca every day.
God bless you, Bean Pat. We all love you so very much.
The local prosecutor added a charge of promoting contraband at the county jail, which, according to the prosecutor, resulted in a discussion with the defense about a plea for second-degree murder in return for dropping that lesser contraband charge. Here is how the prosecutor summed up the matter this past winter.
So when we brought that charge, his attorney began talking to us that maybe he felt that if we would satisfy the promoting charge with the plea to murder in the second degree, that would be something that Brandon wanted to do. As you've probably heard, he videotaped the homicide. All I can say is I'm very grateful that 12 jurors from our community don't have to see what Brandon did to Bianca. This case will always stay with me. Not a lot of folks have actually seen the video, the content, because it is horribly graphic. It's absolutely monstrous, and it's something I'll never forget. This will be one of those cases that will stay with me for the rest of my life.
Okay, Brian, I don't want to misconstrue what the prosecutor said, because it sounds like she was considering adding charges around the time the defendant was considering pleading guilty, and the defense turned around and said, okay, well, you know, there's a plea in the works here, so why don't you lay off the lesser charge and we'll just go forward with the plea on the big charge. But does that sound right to you, or does something seem amiss?
It seems pretty commonplace. At first, when I heard this, I thought, well, maybe they're trying to supersede with stronger charges, and that might be a reason to motivate or manipulate, as the defendant might think, to take this plea. But he shouldn't really be concerned of those lesser charges when he's looking at that murder charge. The only thing I can think might happen here, this might be an issue of form rather than substance, and the defendant is saying that he did not knowingly and voluntarily take this plea, even though he admitted to it. Maybe he's saying he's coerced by his defense attorney.
It's an interesting procedural case. Terry, how hard is it to actually claw back a guilty plea?
Well, it's going to be hard in this case because he was so forthright in the plea. He stated so much during that hearing. He said he was sorry. He said she did not deserve to die like this. And so I think that it's going to be difficult to claw it back. But you know what? At the end of the day, they may just do it just because the judge in the court wants to make sure that his due process rights are not violated.
That's a great point, Terry. But again, good judges are very careful about getting solid pleas on the record to avoid this situation. So we will certainly watch this case. And later on in the broadcast, a boyfriend attacked in an alley, a girlfriend later found dead. Who did it? Police say they have finally found their man after 46 years. Plus, federal authorities explain why they think R. Kelly should remain in jail even after he was attacked behind bars. That's when Law and Crime Daily continues. Time now to check in on other high-profile cases we are tracking here at Law and Crime Daily. Federal prosecutors say that embattled R&B singer R. Kelly does not need to be let out of jail before his upcoming sex crimes cases go to trial. Kelly, seen here at a previous hearing, argued to be released because he was attacked at Chicago's Metropolitan Correction Center. Authorities say they moved Kelly's attacker to a different facility in Michigan, and therefore the threat no longer exists against Kelly. The family of Don Lewis has filed an amended legal document against Tiger King star Carole Baskin. Lewis's family and Lewis's assistant are trying to dig further into suggestions that Baskin had something to do with her former husband's mysterious disappearance and presumed death. The amended bill of discovery uses Baskin's own words against her and adds a claim for defamation. Don Lewis's personal assistant, Ann McQueen, claims Baskin has been lying about her since as far back as 1997. And now to Chief Investigative Correspondent Brian Ross for a check on what he's working on this week.
Thanks, Aaron. Coming up this week on Brian Ross Investigates, the president, the playmate, and the crucifix. New details about a gift that Karen McDougal, former playmate, says Donald Trump gave her in the middle of what she says was a 10-month affair.
Donald had given me those items personally. He thought they were amazing gifts, and he thought about me.
Mr. Trump has denied any affair, and his office denies there was any gift. We'll have all the details coming up on Brian Ross Investigates on the Law and Crime Trial Network. Back to you, Aaron.
And when we come back here on Law and Crime Daily, an arrest in a 46-year-old cold case. Evidence detectives are saying led to the break when we return. Texas authorities say a family there now has answers to a 46-year-old question. 17-year-old Carla Walker attended a Valentine's Day dance with her boyfriend in 1974. An attacker pulled her out of a car in a bowling alley parking lot. The boyfriend was attacked and Walker was kidnapped. 3 days later, Walker's body turned up in a culvert. Using genealogy techniques similar to those utilized in the case of California's Golden State Killer, investigators recently retested the victim's bra and got a hit for a suspect's DNA.
Basically, when we had done testing before, sometimes when you do testing, you don't always get a full profile. This time when we retested, we got a full profile, and that allowed us more options available to seek out who this could be.
And to be clear, you mentioned retested the bra, you got the full profile.
Correct.
And why did you get the full profile? Like, how does that happen? Why?
Just new technology, different people trying different methods. DNA has been around basically since the mid-'80s, but there are continual advances in how they attempt to find that DNA and then also how they extract that DNA. So it was these newer processes that enabled us to get a full profile as opposed to a partial from before.
Walker's parents have since passed away, but her brother says the family is thankful for the arrest.
The word that came across my brain was finally. Finally. After 46 years, 5 months and 3 days. We have a name, a face, and we're moving toward complete resolution. I would like to sit here and tell you, no, I never gave up hope. But there were really dark times, and watching the pain my mom went through, you know, I can tell you, this whole case being resolved is a thank you, God.
So, Terry, the authorities make this sound so definitive, and what's disturbing about this is that there's no link between the suspect and the victim.
Right. Well, you know, a random crime is generally more difficult to prove because you don't have a motive to link you back to the defendant. So that is why genealogy is so important with these cold cases, because they can take the DNA from the defendant, and they did here. They took it from his trash can, and then they can match it to the DNA that was found on the victim, and that's exactly what they did here. So fortunately, we now have techniques that can solve these cold cases. It's like the Golden State Killer, as you said, and it also reminds me a lot of the Jerry Burns case that we recently reported about in Iowa.
Exactly. So, Brian, the question, though, is this really case closed? We've got to wait for a plea. We could have a trial here. There could be a defense.
I still think that we're pretty far from thinking about this being a case closed. There are still a lot of questions that are unanswered, and simply having DNA doesn't prove guilt or innocence either way. There are going to be a lot more supporting facts that lean one way or the other, and it's up to the lawyers and the evidence to figure out where this leads for the jury.
Keep an open mind, because you never know what the plea might be. There may be a good defense here. We'll have to see. Thank you so much for the analysis, Brian and Terry, and thank you for joining us as we discuss justice in America, in our police departments and in our courts, right here on Law and Crime Daily.
I'm Dan Abrams, and this is the Law and Crime Network.
The only 24/7 network with expert legal analysis and gavel-to-gavel live trial coverage. Watch the Law and Crime Network today.